I'm Patrick Penninckx, and I will be chairing this, but when I was asked to chair, in fact, it was not very clear what the role of the moderator and what the role of the chair is going to be. So it reminded me of a poster I had at one point in time, which said, sometimes I sits and thinks, and sometimes I just sits. So the main person that is going to be moderating is Peter Swire, who is sitting next to me. I just wanted to say from the outset that it is clear that expeditious mutual legal assistance is one of the most important conditions for effective measures against crimes and other offenses, cybercrime, other offenses, involving electronic evidence, given the transnational and volatile nature of electronic evidence. In practice, however, the current mutual legal assistance procedures are considered too complex, lengthy, resource-intensive, and inefficient. The Council of Europe, we did a detailed assessment of the functioning of mutual legal assistance within our Budapest Convention, which is dealing with cybercrime, and it basically brought out this same material, inefficiency, and that we also came up with a number of proposals, which I will not detail right now, but I will leave the panel to be able to discuss those. So Peter,
Okay.
you will be moderating.
Okay.
Floor to you.
Thank you, Pat. Thank you, Patrick. Is this on? Can you hear me in back? You can hear okay? Yes, no? Yeah, thank you. So my name's Peter Swire. I'm a professor now at Georgia Tech in Atlanta, Georgia, which did not get snow last week, but Washington did. This topic I'm going to introduce very briefly, and then we have a fantastic panel that's going to speak, and we'll have a chance to talk back with each other. Part of the interest in mutual legal assistance is happening because communications for ordinary people have gone global. And so imagine, for instance, if there's a crime that happens in Belgium, the victim is Belgian, the suspects are from Belgium, and the records are held in the United States, a social network, a webmail, something like this. Under current law, in this case, because the United States has relatively strict rules under its Electronic Communication Privacy Act, under current law, this Belgian activity goes to the U.S. Department of Justice, which goes to a district court somewhere, which goes to the company, and maybe months later, the Belgian police get some information. But this now is not just about cybercrime, some extraordinary, strange kind of crime that's happening for cross-border. This could happen for a very minor crime that happens to take place in one country or two countries outside of the US. And so this has helped to lead to a great deal of discussion about how to proceed. At Georgia Tech with my researchers, Justin Hemming and Suzanne Vergnol. Are they here? Justin, Suzanne, you here somewhere? Probably not. They were earlier. We've been writing on this, and we'll have more writing soon. And we'll also be doing some activities this week on this area. So if you have strong interest and want to engage on some of these discussions, come up afterwards, and we can tell you about ongoing activities. But with that as a framework, that there's a lot going on, we have our panel today. I'll introduce each of them very briefly, and then we'll turn to the first speaker. Erin Allbaugh, two people to my left, is a senior counsel with Yahoo, which is a global company that faces requests from who knows where, and Erin knows all about that. He'll talk about the service provider perspective. To his left, well, sorry, not to his left. To the end, we're going to go next to Bertrand de la Chapelle, who is an expert in France on the Internet Jurisdiction Project and has seen this issue in terms of the broader views of Internet policy. For instance, if the local police don't like to go to other countries for evidence, maybe they require all the records to stay inside their jurisdiction. And then we split up the internet into many small pieces, which has some disadvantages. So what do we learn about the internet from this issue? The third speaker will be Carly Nist, who's in the middle there. Carly has been at Privacy International, is well known to many of you as an insightful expert on these issues from a civil society perspective. And as these rules get changed, maybe civil society gets better protections for citizens of different countries and for political dissenters. Or maybe the rules get changed in a way that leaves less protection for privacy. So this is why we're at CPDP, a privacy issue, because it's records of individuals that are being affected. Our final speaker will be Gail Kent, who is currently at Facebook and has very extensive experience in the UK as a prosecutor and has seen these issues from that perspective. And she will comment on the various other things from her own experience in this. So with that as a start, Erin, could you please go ahead?
Sure, thanks, Peter. I'm Erin Allbaugh. I run the global law enforcement and security team at Yahoo, so folks on my team review and respond to all the government requests for user data that we get from around the world. And I thought it would be useful for the first few minutes to sort of just talk a little bit about how the process works operationally in terms of the types of requests U.S. providers get from governments outside the U.S. and sort of the spectrum of approaches that providers take. Obviously, not every provider handles the request exactly the same, but I can talk generally about how this works and list a few of the big challenges that I think the industry is facing right now in terms of limitations and constraints on the status quo. So under U.S. law, I'll split it into three types of requests. There's, sort of non-content requests. Some people call it metadata, but basically requests other than for content. Then there are content requests, and then there are requests that providers receive in emergency situations. And I'll just speak briefly to each of those because they're each a little bit different. Under U.S. law, providers are permitted to, but not required to, disclose non-content data to governments abroad. So things like account registration information and IP logs, providers have discretion to decide what to do about those types of requests. There is I think this is the one where there's the largest range of approaches among different providers. There are some providers who fairly regularly disclose non-content subject to legal process from other countries. There are other providers that generally don't do that. For providers who don't disclose non-content data, they'll refer the government to the MLAT process. And I'll speak to the MLAT process in a second. Because with respect to content requests, US law prohibits providers from disclosing content like an email communication, for example, to a government other than the US government pursuant to a search warrant. And so across the board, all the large and small US providers who receive a request for content from a non-US government are legally required to reject the request and tell the requesting government to go through MLAT, which, as Peter mentioned, involves a government-to-government process. It frequently can take, at this point, close to a year from the time the request is originally submitted to MLAT to the time a provider may ultimately disclose the data. Needless to say, in many cases, data 10 months old is irrelevant to the requesting agency and essentially useless. Emergency requests, this is cases where someone's life is imminently in danger. At times we get these requests and providers have the discretion to disclose data in emergency circumstances. And I think each provider, certainly Yahoo, has sort of some very detailed criteria internally in place for deciding whether we're satisfied that it's truly an emergency serious enough to warrant disclosure of our user data. That's sort of the three main categories of what happens from a provider perspective. I think as Peter and Patrick both alluded to, because providers are really sort of in the middle of a process where it takes a long time for law enforcement, who in many cases has very legitimate need for the data, either for law enforcement or security purposes to protect their citizens. We as an industry are facing a lot of different types of pressure from governments who are trying to get the data more quickly. The MLAT process, for example, is slow and inefficient. Governments are under-resourced. They don't have sufficient staff to process the requests as quickly as law enforcement needs the data. As I mentioned, the current U.S. legal framework prohibits providers from disclosing content to non-U.S. governments, so the U.S. Internet industry is really just stuck on that issue. There's nothing we can do. Another thing that I've seen, and I think some other companies have seen too, is increasing pressure from governments outside the U.S. to get us to expansively interpret our emergency exception as a way to get data when there's no other way to get it. You know, it leads to some difficult conversations, a fair number of differences of opinion on what constitutes an emergency. And then from a sort of policy legislative perspective, I think many of you are aware, I mean, there's a trend now toward forced data localization laws and laws which purport to assert extraterritorial reach outside the local country to reach U.S. providers and providers all over the world, I guess. The Investigatory Powers Bill in the UK certainly asserts broad extraterritoriality. Russia, France, and Brazil are other examples of countries that have adopted or proposed very aggressive surveillance laws in the last year. And then, in addition to all that, so basically, we have a situation potentially in some countries where companies have irreconcilable legal conflicts where to comply with the law of one country would require violating, in some cases, criminal provisions of another country's law, specifically U.S. law, which would be challenging enough under any circumstances, but the additional pressure that we face, a very real human pressure, is that there are countries who have put the threat of criminal liability on employees and officers in the local country for the failure of essentially the parent, the U.S. company, to comply with a request. As you can imagine, when that happens, you're really caught between a rock and a hard place. And the employee or officer of the local company entity is really stuck because in most cases, that person has no control over what the folks in the U.S. do about the request. But of course, the folks in the U.S. are very concerned about their employee in the country. So you can imagine it leads to some very difficult decisions. So I and a number of people have been working on thoughts for how we might change the status quo, but I'll stop there, I think, Peter, and we will come back to that.
Thanks very much. Bertrand?
Thank you. Just building on what has been said and putting it in a somewhat larger context, we're all confronted with a dual challenge at the moment, which is, on the one hand, whenever we talk about jurisdiction on the internet or in cyberspace, the first challenge is to preserve the global nature of cyberspace and at the same time manage the respect of national laws, which obviously are sometimes in conflict. And the second element is, given the need to address misuses or abuses of the internet, we need to develop mechanisms for cooperation, but at the same time make them work with the full respect of human rights and protections and due process. These two tensions are particularly significant, and they're becoming extremely visible now because, as was mentioned, almost every single human activity is now involving the use of electronic tools. And in as much as the internet has allowed interactions between people across borders, that's obvious. The particular case that we're facing here is that the tools that people use introduce a transnational dimension even in interactions that happen on a single territory. So the simple fact that major US-based platforms, or sometimes platforms that are based in another country, are actually used by people in the course of activities that are deemed criminal or require investigation is bringing a transnational dimension to things that used to be exceptional. And so not only that, but you got also the problem that investigations that were done on a paper trail in the past are now requiring access to electronic data because this is where the information is. And so when you look at the statistics, I was discussing with somebody at DOJ the other day, and they were telling me that in the last 10 years, the number of requests that they are receiving has grown by 1,000-fold. I mean, 1,000% increase. And this is not going to abate, quite on the contrary. So, as has been mentioned before, the problem is, in light of this explosion, the system is broadly, the system of mutual legal assistance treaty is broadly considered as being broken. And I have a personal label for this. When you think about this system of mostly bilateral agreements, it is like a switch network of international cooperation. It is something that is very hard to scale. If you want to have as many bilateral arrangements among 190 countries, not that, of course, Tuvalu and Nauru are going to have a very big MLAT problem. But if you just do the math, it's tens of thousands, 15,000 or 17,000 potential bilateral agreements. And so scalability is a problem. We get another problem, which is the fact that in many cases, not always, but in most cases, you need dual incrimination. So if something is criminal in one country but not criminal in another, the MLAT system will not be able to cover this. And you get, obviously, the question of speed. And the problem of speed is, of course, a matter of efficiency. And we can talk about the improvement of the workflow. But there is also a question that is related to the fact that all the different steps that are being put in there are put for providing protections. And so there is a keen tension in any attempt at simplifying the workflow and keeping the protections at the same time. And so the bottom line in this mutual legal assistance treaty discussion is that we're confronted with a system that is fundamentally based on the separation of sovereignties. And the separation of sovereignties, as Javier Solana, who was then the NATO General Secretary in 2008, I think, was saying, actually, the separation of sovereignty is not conducive to cooperation. It's conducive to competition, and certainly not to finding the mechanisms for working together. So in this environment, as was said, we're in a situation where intense frustration and legitimately felt frustration by law enforcement in different countries, given the delays, the complexity of the procedures, and so on, is putting everybody on a dangerous path, because either there are issues of data localization, there's the conflict that was mentioned about being caught between a rock and a hard place, like abiding by one national law is actually putting you in conflict with another one. And the key challenge is that we're in a sort of legal arms race at the moment. Because there is no international arrangements that are emerging, there is a difficulty of bringing the multilateral arrangements that we normally develop. And in spite of the very valuable efforts of the Council of Europe, it is difficult to bring a multilateral type of arrangement. Every single country is trying to develop the tools that they have. And the end result is this competition on the legal space that actually makes the problem harder to solve than providing a solution. So in this environment, what I want to highlight is there is a very important distinction. There are many distinctions we can make, but there is one that needs to be kept in mind when we approach this issue of MLAT reform, is to make the distinction between what I would qualify as the process re-engineering. Like, we keep the things functioning more or less the way they are, but you implement more electronic circulation of the information, formats for the submission, speeding up the communication between the different actors so that all the different steps can be done faster. That's one aspect. And this includes also education. This includes potentially in the different countries having courts that are dedicated to providing this type of validation at the national level. But it includes also resources, human and financial resources. For some of you may know that I think last year or the year before, there was a request by the US administration to get additional funding for the MLAT processing by the Office of International Affairs in the Department of Justice. And this request for $20+ million was actually not granted by Congress. So when you talk to people at the DOJ, The piling up of requests is making this absolutely unmanageable. So this is understandable. But that's the first element. What I would like to focus or to highlight as a second element is something that is emerging as a core discussion at the moment, and echoes what Peter was saying at the very beginning. There is, at the moment, a question that is being addressed, which is, should there be a sort of special regime for situations where the only nexus of connection with one particular country, in particular the US, is the use of a US-based platform? In other words, if, as you mentioned, all the activities like the perpetrator, the victim, the requesting authority are in one country or even in several, but have nothing to do with the US, apart from the fact that a US platform is being used, should there be exceptions? Should there be a different system? Should there be a system where, for instance, the request would not go in the US to the Department of Justice through the traditional channels, but would go directly to the companies? And if so, what are the criteria? Who would be the countries who would be allowed to have this expedited process? What is the criteria? What are the criteria that should be used to evaluate whether a request is validated or not? I won't go through the list, it can come in further in the discussion, but I want first to highlight this very important distinction when we talk about it. Streamlining or improving the current mechanism, or discussing potential exceptions or potential additional expedited mechanisms. And the final point I want to ask as to raise as an introduction is, today there are proposals that are being made in the US, and there's a very lively discussion that is taking place. I mean, Peter Swire himself has been contributed to this debate. People at the Center for Democracy and Technology, such as Greg Nogem. There's a proposal by Jennifer Daskal and Andrew Woods. There are many, many discussions that are taking place on this second pillar that I was mentioning, potential exceptions. What is intriguing and what is something that we need to be careful about is that this discussion is legitimately taking place in the US because, among other things, it might require change in one of the fundamental legislations, which is the ECPA, Electronic Communications Privacy Act. And it is legitimate that the discussion is taking place in the US, but we need to understand also that whatever is being envisaged or implemented will impact mostly actors that are outside of the US. And so there is an important message, which is, in the course of this discussion, there needs to be an involvement, like we are doing here in a certain way, but also the work of the Council of Europe and other actors, to make sure that the viewpoints and the perspectives of the actors that are outside of the US are taken into consideration in the discussion. That's some of the things that, as the Internet and Jurisdiction process, we're going to do this year. But I would just wanted to highlight the very important need to have this broad multi-stakeholder discussion involving the companies, civil society groups, and the governments around any reform of that sort. That's it for me.
Bertrand, thank you for that intervention. And part of the reason to have this panel today is exactly that, is to try to get the bridges built more effectively here. And if there's people in the room working on these issues, as I said earlier, and you want to continue in these discussions as a significant activity, let us know afterwards so we can try to include you in that. Carly, civil society.
Thanks, Peter. Yeah, I might kind of take a step back from where Bertrand ended up there, because I think this issue is, at its essence, a hugely high-level one in so many respects, particularly when you talk about EU-US kind of diplomatic negotiations, when you can bring in the Schrems decision, when you bring in evolving standards around surveillance in Europe, which seem to change every week with new decisions of the European Court. I think it's a hugely kind of cutting-edge legal and political issue. To take a minute to bring it back to questions around individual privacy rights and how they are affected by this process. I remember in 2010, 11, 12, when the first transparency reports were released, and actually when the INJ project, I think, first was getting off the ground, cross-border access to personal private data was really the hot surveillance issue, actually, right up until Snowden hit. This idea that governments were going to companies in the US and asking for our information was really, certainly we as privacy advocates felt hugely outraged by this, and the companies responded in turn with very effective measures around transparency reporting, which really brought to light this process that I don't think many people had quite understood the breadth of. And then Snowden hit, and obviously we got much more preoccupied with other forms of surveillance. But I think it's very important to recall that, of course, any effort by a government agency to get access to private information is an act of interception, acquisition of data that has to be justified in accordance with the necessary rules. And so that's what we should look for to the MLAT process to achieve, to ensure that the protections are there. And I think it's easy to get sidetracked with the concept that there are so many of these requests these days, and there really are, companies really are overwhelmed with requests for data. Governments really are trying to solve the problem of getting access to this information. But each instance of access to data is, of course, a form of surveillance affected against an individual. And so even though a process may be onerous, I think it's important that that process exists. The current system is both problematic and positive. It's problematic in the sense that it is incredibly slow, as Erin said. It really is creating huge barriers for law enforcement agencies to get their work done. And more importantly, from an individual privacy perspective, it's creating perverse incentives for states to do other forms of surveillance, to try and get around these processes by hacking, by installing fiber optic cable taps, by trying to get around or circumvent encryption, and to get the data at its source rather than wait until it's in the company's hands. And so from a privacy perspective, it is certainly in our interest to speed up the process to the extent that speeding up the process will reduce those incentives. It's really problematic in another sense, and that is that there is no process for access to non-content data, as Erin said. So the lengthy MLAT process that we've been talking about is about access to content of communications, but subscriber information, metadata, communications data is not required to go through the MLAT process. And as we all know, and I think it's a trite to say these days, but communications data is, of course, hugely valuable from a privacy perspective. In some instances, it's more valuable to law enforcement and certainly to intelligence agencies. And therefore, from an individual privacy perspective, the system is broken to the extent that it doesn't require an onerous process or a rigorous process to provide access to communications data. And in case you didn't know the numbers, law enforcement agencies are accessing this data from all communications providers, not necessarily American-based internet companies, in the hundreds of thousands a year. In the UK, somewhere around 500,000 times a year, the police seek access to communications data. In Australia, it's somewhere around 350,000 times a year. So that is a big problem with the current system. The current system is positive because it applies US legal protections to surveillance requests in circumstances in which the US, and I hesitate to say it, does have a rigorous and comparatively high standard, legal standard, applicable to content-related requests from law enforcement. I'll really caveat my statement in that respect. But the US does have one of the best systems. They have a high standard of evidentiary proof in order to get access to content data. And it is a rigorous system. The reason it takes so long is that the request has to go through the Department of Justice, who validates the request, who then sends it on to a court. And then the data, before it goes back to the requesting party, goes back through the Department of Justice, who ensures that data is minimized and no excessive data is provided. From an individual privacy perspective, perhaps not so much for me in the UK, but certainly from those countries where there is either no surveillance law, there's no functioning court system, there's no authorization process, this is a really important check on privacy rights. So it is good in that sense. So just to finalize then, I think that any reform, and I agree that there should be reform so that we can minimize those perverse incentives, must achieve two things. It must retain the rigor and retain the protections that it currently gives to those who live in countries that don't enjoy the same level of privacy protections as those in the US. And secondly, it must deal with this problem of access to metadata or communications data, because that cannot continue to exist outside the system from my perspective.
Thank you very much. Gail, you've had different experiences in this space. Could you provide comments?
Yeah, thank you, Peter, and thanks for inviting me. I feel like the MLAT process is a bit like an elephant for me. I have looked at it from lots of different angles, and both from locally and globally. I now have the surveillance, global surveillance and law enforcement policy development portfolio in Facebook. But I spent 17 years working in UK law enforcement in the National Crime Agency, looking at cyber issues and also looking at some big international crime problems. And about 5 years ago, when I had the international cybercrime portfolio and I was starting to look at the Budapest Convention, people were consistently coming to me and saying, well, why can't we get this data? Like, what's the problem with it? And the NCA were kind enough to send me to Stanford. It was very difficult to spend 6 months in California, but I managed it to try and sort of like and get a better handle on what exactly this issue was. And that was a fantastic time, just trying to look at it from all these different perspectives. And I think we've got to the point, and I'll finish up by saying, I think where are we on what next? What does it look like? But it was a great time. I think we've got to the point where we're starting to all have these conversations, and it's less like trying to describe an elephant from different perspectives. So I think like we all agree that there is absolutely a need to move forward past MLAT, which was created primarily to deal with extradition requests and evidence that went along with extradition requests, and now is not just responsible for assisting in some of the really fast-moving cybercrime cases that the Budapest Convention was set up to deal with in the first instance, but also it is there is as Erin and Carly have said, this is to deal with evidence in such a wide variety of cases. So it can be everything from really complicated cybercrime cases to domestic violence, which is happening in one country between two people that live in that one country. So we've also, I think, all talked about or acknowledged the difficulty in updating it. There is definitely the issue of the clashes of sovereignty that Bertrand referred to, and how do you deal with what is happening in one country with what is in fact a very, the internet being probably the most international communication mechanism that we've ever had to deal with. And then the complexities of dealing with updating a complicated process and dealing with the privacy of individuals and those that have the data when there are different privacy standards around the world. But I think what we absolutely have to acknowledge are the consequences of not dealing with that, whether that is extraterritoriality or data localization, and the impact that has on companies, on having to deal with a chaotic legal environment and complicated conflicts of law, and working out, as Erin said, which one we should be following and which one is the most important one. But also then the impact on the user if we're going down a data localization route. And I don't think that's just about necessarily about surveillance, but what is the impact on things like innovation and on the ability of companies to provide the sort of services that we're now used to through the internet. And I think, though, we also have to acknowledge, and Carly and Erin have both talked about sort of like legitimate law enforcement investigations. So what is the impact if you are not providing data, not just for the victims of crime, but also in if that's part of defence, if that isn't sort of going through the MLAT process in a way that is speedy. So I think that it's been sort of really interesting seeing how the debate has developed over the past 4 or 5 years. And Peter pointed out that there's been an awful lot of talk, and I think we've got to the point that it's now time for action. And I think, like Peter, your writing is definitely sort of pointing towards that. And we've also talked about the Daskell Woods Agreement, and I think that the interesting thing is about coming together and having these discussions. This feels like a real moment where all the players can have an impact on what comes next. Because I think we are agreeing that if we don't reform MLAT, we're looking at a far worse situation than if we do reform MLAT. But it feels like this is a time when governments, civil society, and companies are willing to come together and look at what some of those solutions are. So if you are interested in this, it's definitely worth looking at some of the writing and blog posts that have been on it, whether that's Greg No Gems on CDT or the Daskell Woods blogs on Lawfare. And I think there are, as Bertrand pointed out, there are two different things that we can look at here. There is the streamlining, but there's also what does it look like if we could absolutely get to an international framework? What does that look like? And I think from a company perspective, the most important thing from that is for it to be like a race to the top, so that we can absolutely get to race to the top for human rights, rather than looking at it as having to go to the lowest common denominator, so that it's no longer companies that are having to make that difficult decisions, but there is a framework supported by governments and any changes in the law that have to happen. But this means that it's very clear that when data is being handed over, and I think we're primarily talking about content, although there's obviously an important debate to be had about metadata as well, that's done with the highest possible human rights standards, and that we're all in agreement with what those are. But I think we also have to be conscious that this can't just be a discussion. I know that the panel's framed between EU and US, but the internet isn't just about the EU and US. This has to be something that it might not work right now for other countries outside that, but it has to be something where we can at least start the discussion with countries like Brazil that have a very active internet community, that are very active in the human rights standards as well, but where perhaps on the other side there are also presentation of some difficult internet laws. So I think we've, just to conclude, we've got to the point that we really can start working together to come up with some conclusions on this and to move forward, rather than just talking about the MLAT problem, maybe an MLAT solution.
Thank you, Gail. Patrick, Council of Europe has been mentioned many times here. The Cybercrime Convention, also called the Budapest Convention, has detailed provisions on MLATs. It's the biggest, most recent international agreement. From what you've heard here today, what's your perspective from Council of Europe?
Well, first of all, at the start I refer to a study that we did with the parties and observer states of the Budapest Convention, where we did indeed see the question of inefficiency, mainly with regarding to the response times, which have been referred to before. The main question there is probably a distinction to be made on the one side, the adverse effect that it may have not to be able to reach out to certain information on the one side, and the other side to protect the privacy. And there is a positive obligation of the state also to protect the citizen from cybercrime or crime that involves, in one way or another, retention of data through the internet. And what we have seen also through this study is that, first of all, detailed data or statistics on MLAs are not available for the time being. And it may be useful to establish mechanisms to monitor the MLA process related to cybercrime and electronic evidence, because for the time being, we know a bit more about the number of requests that individual police forces make to their service providers, and that goes indeed into the 100,000s. There was a recent article, I think, in the Irish Times that said about the Garda requesting about 66,000 times per year requesting information. A second thing I would like to say is that police-to-police cooperation right now is much more frequent than MLA. And much information can be shared and is being shared, which requires validation before use as evidence in the court, but in the meantime is being shared between police forces. And in fact, the Budapest Convention does allow for a number of exchanges of information between law enforcement authorities. So what is the key question, I believe, and maybe also on the question of content information and subscriber information or meta information. Most of the required information, most of the data requested right now is subscriber information and has been singled out as the most often sought information by law enforcement. The large amount of requests for such information does in fact put a heavy burden on authorities responsible for processing and executing MLAs, and maybe there is a need to find a better system to that. We know that many providers with their headquarters in the United States, they cooperate voluntarily, not only Yahoo, but also others, and disclose information other than content upon a lawful request under certain conditions directly to foreign law enforcement. And that continues to happen. What we're really looking for, and I think that is crucial, is that we need to provide a greater legal certainty than what is currently being provided. When a system does not function on the one side, parallel systems come into place, and which may not provide the same legal certainty than a system which is duly reported upon and elaborated. That's my first reaction to that. I can give you a few elements of how we would see, also from the side of the Budapest Convention, maybe an additional protocol to the Budapest Convention, and the content of such an additional protocol may provide further elements for this legal certainty.
So I think that's something, I have two sorts of questions for the panel, and then we'll open it to the group, and that will be part of the second one perhaps. So we're at a privacy conference. That's the center here today. And so my first question to the table is to think about, from a strategy of protecting privacy in these different nations, how to proceed. And let me set up the question this way. So it's privacy and civil liberties. As was mentioned, in the United States, for instance, if there's a request to the United States, there's a First Amendment review before the data goes back to the requesting country. So if it's political dissent, the Justice Department will not turn over that information to the requesting country. If it's hate speech and other laws that are not criminal in the United States, the U.S. screens that out and won't provide it. So not only is there privacy protections, but there's civil liberties protections built into the system. And that's from compared to a lot of things privacy advocates complain about, that's a pretty strict thing, minimization for that. We also heard the concern about parallel systems, the concern Carly mentioned about if we don't do it through the lawful system, then countries are going to come up with other ways to squeeze the data out of this. So for privacy room here, what's the strategy to get privacy and civil liberties protected between now and 5 years from now? How do we think through, if it's stricter, that's strict. If it's too strict, they'll find alternative paths. How would you strategize to protect privacy here? So I offer to anybody, I don't know if Carly wants to go first or not. Yeah.
So I'll offer one element of a solution, or certainly which I see as a prerequisite to a comprehensive international solution, because I think it should be an international solution. I think there has to be a coalescence of agreement on the applicable standards to all forms of surveillance. I see that as being a necessary prerequisite to being able to come up with an international agreement on cross-border data transfers. And I think there are some key elements of standards applicable to surveillance that there doesn't exist consensus around. And we're starting to see some emergence of consensus in various places, but we're also seeing some gaps opening up and being kind of emphasized, and I particularly point to the Schrems decision, which focused on those gaps, perhaps over-focused on those gaps. But in any event, I think that we are moving towards some more consensus on what are the applicable human rights standards to state surveillance. And three particular areas in which I would point out we'd need to see some concurrence on would be the need for judicial authorization prior to accessing data. And I think that should be built into any international solution to this problem. the need for the existence of a reasonable suspicion. I think this is much more controversial. In many countries that doesn't exist. The European Court is starting to say that it is a necessary prerequisite. I think that would be a huge debate, but nevertheless an important one. And then to touch on Peter's last point there on the free expression concerns, this kind of relates to a larger debate that's going on between, again, the US and the EU around whether or not proportionality is a relevant standard to issues of surveillance. And this debate I've seen mostly from the perspective of working around the Human Rights Council, where the General Assembly and the Human Rights Council have done a number of resolutions in the last 3 years relating to surveillance, as I'm sure many of you know. And they set up a special rapporteur on privacy. But one of the big debates between the countries promoting these resolutions, particularly Germany as a leader of that group, and the United States, on the other hand, was whether or not proportionality is a necessary concern. And by proportionality, I think there's a bunch of different concepts rolled up in that, but in the context of surveillance, it's about whether you should exhaust the less intrusive measures to be able to get the information you want. And also, what is the harm? What are the other harms done by authorizing surveillance? So that would bring in free expression concerns, for example. So that's how the Europeans look at it. The US have a different approach, and I think reconciling those two approaches would be essential. Sorry if I got a bit too much into the law there.
No,
But
so I see Bertrand, Erin, and probably Gail, but Bertrand got his finger up first, so go ahead. Yeah.
I think it's important to use very simple words to drive the discussion. I would introduce two words here as an answer to your question. The first group of words is the notion of due process and how to organize this across borders. And the second element is talking about more transnational agreements than international agreements. I think the implicit notion behind the notion of an international agreement is that it is an intergovernmental agreement. And I think it is extremely important in that discussion to make sure that the discussion is taking place among all the different actors. It may be embedded in the end in a treaty, it may be embedded in the end in the national laws and so on, but it is fundamental that all the stakeholders are participating in this. And to elaborate just one little bit on this notion of due process, we have facilitated during the last 4 years a discussion on some of those transjudicial challenges among more than 100 different entities. And in this notion of transnational due process, touches upon some of the issues that have been mentioned. For instance, transparency. How do you gather statistics on where the requests are coming from and how many of what sorts? The question of even discussing common vernacular. Without getting into details, there's a huge debate at the moment on the criteria of probable cause in the US. Should this standard be the reference standard, or should an equivalent standard be formulated? There is also the question of the First Amendment protection in the US. At the same time, the evolution in the recent years is that platforms under pressure, including from European actors, in situations where all the activity was taking place in Europe, actually communicated information. And for instance, there was a famous case a couple of years ago with Twitter on anti-Semitism, which is criminal in France, and where they provided information about the perpetrator because precisely the person was based in France and so on. However, we have a range of criteria for decision making that need to be clarified. For instance, on criteria of territoriality, is the location of the person relevant? Is the location of the server where the data is stored relevant? Is the location of the country of incorporation of the company relevant? And I want to make a connection here with something that is indirectly related to MLATs. You're all probably familiar with the pending case of Microsoft and Ireland, where we have a sort of reverse situation where a company that is based in the US is being requested by the US authorities to have access to all the data that is being stored, even if this data is being, in terms of content, even if this data is being stored in Ireland, in servers in Ireland. This is a pending case, but it is an element that needs to be taken into account. So I would fundamentally support the notion of greater legal certainty. This goes with the notion of predictability. How clear are the criteria? Is there an agreement on what are the decision-making principles and rules that will be made? Something that is not often mentioned in any transnational process is how do you make redress? What are the appeal mechanisms if you have a trans-border request and somebody is not satisfied with the transmission or not the transmission? What are the channels? Where does it go? And a last element of due process is what are the formats for the submission of those requests? It's very important to see this problem as a sort of interoperability, legal interoperability issue. And if you talk about legal interoperability, you have heterogeneous actors, you have private actors, public actors, civil society groups. We need formats for interoperability so that these requests are being understood on both sides and that they are shaped in a form that is practical. And the last point is, we're talking about agreements. We have a big challenge, which is if we're moving towards transnational cooperation, what is the format for an agreement among stakeholders that are different? We know how to do treaties among governments. We know how to do guidelines and best practices for companies. How do we formalize an agreement between governments and civil society and the private sector on criteria, guidelines, and so on? This is a very interesting challenge. And I just wanted to highlight this because it's a problem that is never mentioned, but that is actually a result of the desire to have a multi-stakeholder discussion.
I think we're seeing the multiple parts of this, law enforcement and privacy and civil society and technology. But my question is back to what's the best strategy for privacy protection? And Erin and Gail had their hands up.
Due processes.
Due processes, Bertrand. Okay.
So yeah, I want to take a stab at that. And as you mentioned, Peter, we are at a European Privacy Conference. It's interesting. I go to lots of meetings with lots of different governments. And there's an interesting dichotomy going on because without naming the member states, there are multiple member state governments who have representatives who are focused on data protection, who have said in meetings, criticized U.S. government approach to surveillance and the things that are sort of wrapped up in the Schrems decision. All fair, all fair. Different people focused on law enforcement in the same government are doing more than you probably could even imagine to try to get data more quickly and more easily from providers in the U.S. And it's really, it's fascinating, and it's a major problem. So I think my approach...
Are you suggesting constitutional change in the European Union? And what?
That's way beyond my pay grade. No, I don't know. What I am suggesting is there's actually a huge opportunity with this notion of this new framework for cross-border requests to both address the legitimate law enforcement needs that exist, alleviate, I should have said three things, not both. The second is alleviate the enormous pressure that providers are feeling. And third, alluding to what Carly was talking about, there's also an opportunity to use this notion of a cross-border framework to up-level privacy and use entrance by a government into this type of a framework as a carrot to require higher legal thresholds to gain entrance and the easier ability to gain access to the data. So I think for Yahoo, and I think for the industry, I can't speak for other companies specifically, but I think we actually see it as a way to try to attack both parts of the problem.
Okay. Yeah.
Yeah, and I'd absolutely agree with that. I think that it's fascinating reading the European Fundamental Rights Agency report, which points out that there only are 5 EU countries that have written down what they are doing when it comes to surveillance. And it's, it's very true that I know what happens in the US, I know what happens in the UK, and I can do that comparison. But if I'm trying to look at other countries, it's very, very difficult to do. So I think if we're trying to sort of like up the game on privacy, anything that we can do that will remove the sort of pressure that Erin was just talking about, that means that countries are stopping doing things in secret, but they're then coming and asking in a framework that we all understand is going to be a good thing. And I don't think that we have to look very far for what those standards will be. I think, as Carly said, there's already been there's been a lot of discussion about what some of those standards might be. So, and probably the easiest thing for me to do as Facebook is to refer to the Reform Government Surveillance Principles. So the fact that the request has to be lawfully authorised, that it should be targeted, that it shouldn't be wide-ranging, that it should be proportionate and necessary, just jurisdictionally bound, and also there should be transparency. Focusing on that, I think if we sort of focus on that, then we can build upwards, and we can look at how can we then encourage countries that aren't openly having these discussions at the moment and aren't using those principles, if they want to then get access as part of this international framework to look at those principles. So I think that that's the strategy around that part on privacy. I think on your question around your second part of the question about sort of speech issues, I think they are that is incredibly difficult, and I think we should start with this is not an easy problem to solve, so let's start with putting those speech issues to one side. And I don't think anyone's suggesting that we've got an either or, that there's MLAT or there's something different. And I think the really difficult cases, including those speech ones, in the first instance should still be going through that the process, the MLAT process that you've outlined.
That's an interesting proposal. I hadn't heard quite so concretely. Patrick, your hand.
Yeah, just quickly, I think it's important that we also do not consider this discussion in splendid isolation. I think what we're seeing right now is indeed an urge for governments to have more access to data. When you look at the Loi sur le renseignement in France, when you look at the build-up of the investigatory powers bill in the United Kingdom, just name two developments: the état d'urgence, the state of emergency in France that has been prolonged. So this is also the climate in which we are discussing. I think it's nice to sit in Les Halles in Schaerbeek, but it's also important to realize that this discussion is also taking place within this context, and we're looking into that because for the Council of Europe this is an important issue. Surveillance is there, and we also want to, even though we want to make a strong separation on the one side between criminal investigation, which is taking place under the Budapest Convention on the one side, and on the other side surveillance related issues, I think we cannot make full abstraction of that. Maybe also a short reminder that European providers, unlike the US providers, are normally not allowed to voluntarily disclose any type of data to foreign authorities, which is maybe also important to recall. And third, I wanted to react to what Aaron was saying concerning the different communities. I'm myself in charge of the Information Society Department of the Council of Europe, which regroups a number of different things. On the one side, the Cybercrime Convention, but also the Data Protection Convention and freedom of expression items. And what I often find is indeed there is very little communication between those communities. And looking at the debate that was taking place in this very room just before this panel, the almost non-understanding in many ways between the law enforcement community and the data protection community, which both forces probably drive into opposite directions. And I think it's critically important, and that's why from the cybercrime perspective, we organized a couple in November, a hearing between internet service providers, internet companies, but also more general providers, data providers, etc., and the law enforcement agencies. And we will continue to do so, also with academia, also with civil society. And I can already say that in May we will be probably organizing a meeting within the cybercrime context to relate directly to the data protection community to see to which extent a number of concerns that we have, providing due process, as Bertrand states it, but also a greater legal certainty. That is what we're all looking for. We're in a democratic, human rights prone society, or at least geared towards that. And we need to ensure that that is what we keep in the back of our minds. Thank you.
Thank you. I'm going to ask one more question and ask for brief responses from the panel. Just to introduce it, one is we've heard about lack of transparency for the laws. So my project, we have an article that will be posted, I hope this week, on the US process in more detail than's been available. We're working on France, Italy, Spain, and UK, which is the language expertise we have. And if there's other people who'd like to help bring transparency for other countries, I think that's one part of coming to some understanding is how the process works in practice in different places. The question I'm going to ask here is institutionally, treaty or otherwise, how do we solve this going forward? A very brief introduction is we've had globalization in other areas. So for instance, people travel between countries much more today than they did 100 years ago. And to address that, there became something that's called the Visa Waiver Program, where you don't have to get an individual visa now to fly from Belgium to the United States. In the old days, you had to wait for the visa and get the interview. So that was a streamlined process, and there's approximately 40 countries inside a set of understandings. That was done by statute, not by treaty. So each country adopts the statute, and if they meet the criteria, then they're part of the system, and it doesn't take a mutual negotiation every time. So how much is that an approach to try to handle a global problem? And just, again, briefly, what are the key institutional things to keep in mind? And why don't we just go straight down the row, Patrick, because I think you have some thoughts here.
Well, I think we're badly placed to respond to your question, because as an
You're already perfect, yeah.
no,
you already do it.
As an intergovernmental institution, we will definitely first to look at intergovernmental instruments and see the advantages of looking at the of what Bertrand stated earlier on, of having to have individual negotiations on a bilateral level, or what we see happen, if I may take your example, what we see happen now in the current context with the developments in the Schengen area is maybe not the best of examples. So I think you need, again, coming back to this greater legal certainty, what are the instruments that we can provide at an international level that will provide for this? And I don't think it's so much a matter of what type of instruments we are looking into, but what will provide this certainty. And in duration as well, not just because the feeling is good. We also know that the US visa regulations can change, and I have a number of colleagues who work directly with me that require visas to go to the United States. So I think it's important that we look at it in a setting which provides the best security.
Thank you.
Yeah, it's a tough one, and there are a number of us have been thinking about the operational aspect, like how would you actually give effect to this notion of a framework for cross-border requests. I would have no philosophical objection to a multinational intergovernmental treaty. I think in an ideal world that would actually be great. I think, having participated in some early discussions with a couple of governments about this idea, I think as a practical matter, you have to define the problem you're trying to solve, because I think if we wait for too many governments to come to an agreement as one sort of umbrella agreement to cover the world, or even some large portion of the world, I think we're going to be waiting way, way longer than the time frame in which there needs to be at least a smaller scale solution. So, my thought is that probably the way to tackle it, I fully agree with Carly that it needs to be a global solution that at least a large number of governments ultimately are involved, but probably a series of bilateral agreements may be the way to start, and that doesn't necessarily mean that is how it has to end. But if we pick some key countries who might be able to participate in these sorts of agreements and sort of get the dominoes to start falling, I think that may incentivize other countries to more quickly become a part of this solution.
Okay, Carly, what institutions do you want to call on here?
I would join Erin on the fence and say I think ultimately we could have an international agreement, potentially one pioneered through the Council of Europe, as with the Budapest Convention, potentially one negotiated along the lines of the Rome Statute, for example. I think that is a potentiality in 10, 20 years' time, but I agree that we're not there yet. And in particular, I would emphasize we need much more agreement on the norms that are applicable to this area of law. And I personally would like to see the impact of court decisions and accountability mechanisms filter up to the politics. I think we're still seeing the fallout from Snowden and all of the court cases that have come out from that. And I think as a lawyer, I have great hope that that will really influence the politics of this. And more generally, I would echo Peter's call for greater transparency. I've spent the last 3 years in court around the UK surveillance law, and I still read it and I don't know what's in it. You know, I mean, the draft bill is a great advancement in that respect, a frightening advancement, nevertheless. But you know, so many legal frameworks around the world are impenetrable still, and we really need more transparency.
Yeah.
I'm going to echo everyone else and sort of a call for pragmatism over having sort of some huge international convention that will take years and years to negotiate. I've sat in one too many ICANN meetings to have something like that, and too many UN meetings. The other thing I think is really important is that you know, there are a number of stakeholders that are involved in this, and as much as it is about laws and clear due process, this can't just be. This does have to model ICANN in terms of taking account of what stakeholders think and not just be a decision between governments.
Bertrand?
Well, I think you're putting your finger exactly on the question that I was briefly alluding to earlier on. There's a methodological problem here, and the way we're trying to address this is to use the notion of a policy standard. The question of scalability is a very important question. We are caught between two bad options. Either you have something that starts as a universal discussion, you bring it into the UN and you go nowhere for 40 years because you cannot simply agree on how to frame the problem. Or you go on the other direction with something that is limited. It can be a Euro-American relation. It can be even the Council of Europe. It can be the OECD. It can be whatever you want. And there will always be some element of criticism saying, I didn't participate in this thing in the first place, so I don't join the regime. So the key question is how to frame a process that is sufficiently inclusive, i.e. that allows the actors who want to participate to get in or follow the process early on, but at the same time brings a critical mass of actors who are willing to move forward, because I think the general thread here is the urgency. I mean, there's no way we can wait in a long process. And so the key element here is to answer the question of by statute or by a global arrangement or a global framework on a treaty. It is likely that the analogy with the visa waiver program is something that has some traction. However, when you look at the question of is there a sort of white list of countries that will be allowed to participate in whatever framework, and here this is what Aaron was alluding to, like trying to find a sum of leverage to say if you want to participate in this expedited process, you need to update your laws and raise your standard, which is a very good system. The problem with this is how you define exactly the criteria of who is going to be in and who is going to be out. And there are already comments regarding if it is a unilateral decision by one country in its own program, like it'd be the US, how to avoid that the attribution of the benefit of this regime is not going to be done partly on political grounds. Like there is an ally here and we want them in because we have other reasons, and it might not be a very high standard of human rights. But the most important thing in my view is how to handle the question that we're confronted with a situation where there might be very legitimate requests coming from quote unquote bad countries that would be outside of the regime. And there might be very, very bad requests coming from very good countries. When you talk to law enforcement in private, they do recognize that there are very bad requests that are coming from very respectful countries. And so we are caught in a dilemma here. The white list type of approach is a potential leverage, but we have a problem of what are the criteria and who establishes who is in and who is not. And if you want to go the other way around and trying to do it on a case-by-case basis by putting very high due process standards for each request, it brings an incredibly heavy discussion on what are the criteria for one specific request to be accepted or not, and who makes this decision. And here I want to highlight the point I was making at the beginning.
Yeah.
Sorry, which is the distinction between exception system for issues where the nexus of territoriality is not connected to the US in this case, and the general MLAT reform process. Sorry, I was
I made a mistake. I didn't see what time this session ends. Is it 5 o'clock or quarter of? Does somebody know? In 2 minutes. I'm sorry to the group. I hope
we started late.
I hope in defense of having the panel speak, there's people with very different experiences who've come together to explain things that I'd not heard in public together all in one place. So my apologies to the room, and we'll be here afterwards to talk. Patrick, you were the person who raised his hand briefly just at the end for a last statement, so we'll do that and then break.
Yeah, well, 2 minutes, I don't want to. The main thing is, what I see is that it's all a question of how urgent and important member states or states, or the importance that states give to it. Just to give you an example, and it's not a process that needs to take 20 years, it's maybe also related to the context. There is in the Council of Europe a convention on the fight against terrorism. They formulated an additional protocol with relation to the foreign terrorist fighters. This was approved in a record period of 6 weeks and opened for ratification within 6 months. And even the ratification by the European Union was made within that same period. So that basically means that if there is an urgency, if there is a request, if there is a will, there is a way. And that's what I would like to say on that.
Okay. Let us all thank the panel very much for such an informed discussion.